because only 2 days are remains, my lord, and we are making a prayer for stay, my lord. It's small matter, my lord. It will not take time only.
Matter is small. Your list is already out. And
Understood.
we have fixed, in fact, many mentioned matters for tomorrow because
It will not take time. Only, my lord, only thing is that despite my lord, the limitation was issue was decided negative, and despite of that, my lord, decree was passed, my lord. And now we have been directed to pay 13 lakhs rupees, my lord, from 12.
Majorly, okay. Madam, similar prayer from day after tomorrow, madam. FAO, madam. Thank you.
after Bihu only.
Hello.
After Bihu only. Immediately after.
Nevertheless, Lordship. I victim I think one Lordship. Only I don't have a total Lordship.
After purification.
After purification.
Purification has a date.
Please, Your Lordship. Beg to mention item number 17. My senior counsel is unable to appear today due to his mother ill health. Please adjourn the matter for today.
You are MS? Your good name?
Sangeeta Kumari Gupta.
The request made by Ms. S.K. It might be section.
For bail hearing, I can go ahead.
Your Lordship, may kindly pass over the matter for the time being.
It's a simple case of admission. We can admit.
Your Lordship, my senior is on legs.
We can admit the appeal. What is the harm?
Your Lordship, item number 11. I'm presenting item number 11.
Item number 11.
Yes.
Item number 2. You're for item number 2?
I don't know. You know, we are going to file an IA to do some additional evidence. So one day time will be granted.
No, this is case is listed for admission in admission column. You want to file what?
Additional evidence.
It has to be heard, no?
IA for additional evidence. I do some additional evidence.
You're going to file?
Yes, sir.
No, you file, but matter may be admitted. Is there any issue? The request made by Lanet. Yep. The matter be listed after application as an edit.
Maybe. Lord, this is an appeal for enhancement of award, MSCT award.
Well, appear for response number 1.
Company.
Company.
I complain, insurance company.
Yes, your insurance company. 2 and 3 is not it.
21 and driver.
So we're going to admit the appeal.
I call for the record.
Part with a JC of Ilanet Company.
Now response number 1.
It's an appeal 173 and this award dated 38 to 20 passed by London member MSCT Kamrup M. Guwahati in MSc case number 1636. Matter is admitted. Also heard Mr.
R.C. Paul.
The Learned Council appearing to issue notice to the respondent number 20. PC with the matter recording, listing it up to.
Bless.
Neil, please, your lordship. Lordship, this matter has been wrongly registered, your lordship. Lordship, the IA which was filed for continuation of delay was dismissed by order dated 27/8/2025. Along with the IA, the
I-
appeal which was yet to be registered was also dismissed, your lordship. And also, lordship, there has been a settlement between the parties, your lordship.
No, but as the appeal has already been dismissed,
Yes,
pass
along
any
with
order in that.
IA.
Pardon?
The appeal has also
In
been
IA, your IA, the continuation delay was dismissed.
dismissed.
And in the last call, I mean, the last sentence is that consequently the connected appeal is
Yes, your lordship.
yet to be dismissed, also stands dismissed.
Yes.
So now, if there is any, suppose any compromise and all, then also in that case also we cannot pass any order in the instant appeal. You may, it may be settlement before the outside court, and then I don't know if there is any way out. That can be settled. But with this present appeal, we cannot pass any order, and that too, even after suppose you file a second appeal or fresh appeal. In that case, also the question of limitation would definitely arise.
No, your lordship, the matter has already been settled, your lordship. In Sipsagar.
Payment has already
Yes,
been
your
made.
lordship.
Otherwise, also it has already been disposed of.
Yes.
MSC. You are MS
A.N. Hussain on behalf of B. Gopal.
A.
N. Hussain.
Card MS and Bush return appearing on behalf of your appearing
B. Gopal, Mrs. B.
Mrs. B. Gugoi for the applicant of card. Mr. You are for the respond number?
Teachers complaint.
Company respondent number what?
We have not got a copy also. So it may be
Oh.
in I know two, I think.
Respond number 2, I think.
Yes.
Take care for the respond number 2. Full stop. It is hearing the submission made by MS Boots. And on basis of the record, it is seen that the IAC 478 of 16 has already been disposed of, and the delay condonation of delay petition is also dismissed, and consequently the connected the present appeal, which was yet to be registered, also got dismissed in view of this. The present
All accepted.
Please, Your Lordship. Appeal has been prepared by the insurance company, Lordship, against the judgment of Lord MSAT 2 Kambu Metro, Lordship.
You are for the
I am for the insurance company. I'm the appellant here, Lordship. And earlier delay was condoned, Lordship. And Lordship, this is a very peculiar case, Lordship. It's a very high value case also,
What was the awarded amount?
Lordship.
Award was
Award was 90 lakhs.
90.
90 lakhs, Lordship. But some
He was a service holder.
I use a service holder of IOC, Lordship.
What?
And we
Now
have
you are challenging basically the quantum.
not on the quantum, not on the quantum. We are on the merit, Lordship, because there are two views where possible, Lordship. Because, Lordship, it's a doubtful case.
Okay, then we have received the case record here. Case pricing this year.
LCR needs to be called for. LCR will reveal everything,
We
Lordship.
are going to, you are for the.
I have got a respondent 1 to
The claimant.
claimant. Yes.
Owner and claimant has a
He is the owner and rep.
You are the owner and rep, and you are the respond number 1.
1 and 2 claimant.
1 and you are Mr.
PJ Burman.
we're going to admit the appeal. Let the LCR be
Lordship.
called for.
Lordship.
Matter may be listed for hearing.
Lordship.
Part Mr. P.T. Yeah. Also, part Mr. Dick did not appeal for the claimant respondent number 1 and 2. And Mr. D. Mondal did not appeal for the appeal. Sorry, respondent number 3, you also company, or, oh, sorry, owner drive.
Owner drive.
This appeal is completed. Let the LCR be called for. Yes, you will be this matter. So 2 and 3, if we are appealing for the 3, then any other response?
No,
Yeah.
no,
No,
everything is.
This is a matter after immediately after on receipt of releasing
Lordship, there is I also pending
Ah.
for stay, Lordship.
stay.
But yes, Lordship.
So here you are going to deposit 50%.
Lordship, Lordship, that matter is right now. I want to apprise this honorable court that 50% aspect, Lordship. This is statutory appeal, and as per 173, Lordship, it says 25,000 or 50%, whichever is less. And we have already deposited 25,000 statutory deposit, Lordship. And
No,
this
but-
matter, your
Statutory
Lordship,
deposit.
Lordship.
That was the statutory.
Yes, yes,
That
yes.
is for only
No,
filing
no,
of appeal.
let me submit. Lordship, this matter is right now sub judice before the Honorable Supreme Court, and the same line, Lordship, some similar matters are pending, and where 50% deposit order has been challenged, and that has been stayed in one case, Lordship, that is Pradeep Kumar.
Okay, then do.
That is different, Lordship.
Lordship,
In all the
it-
all the cases, each and every cases are different.
Yes, I know,
In
Lordship,
this
but
case,
here,
Lordship, we have reduced 5 evidences and they have reduced 4 DWs. And main issue is that they are talking about the failure. I am riding the vehicle, but it was filed against the driver of the vehicle. I am the pillion rider. That is the issue. Main issue is that. Nothing more than that. Anyway, they are lingering the matter.
No,
without
Lordship,
any-
no, Lordship. We are on the merit, Lordship. There is a definite, in this case, Lordship, there is a vital witness. This is the IO, Lordship. He
Okay, then
says,
we'll do one thing. We'll pass the order of stay here, subject to 50% of the deposit. But
Along with interest.
we're not going to allow to.
Lordship, this matter is right now. I'm flexing.
No,
No, Lordship,
Well, I'm
deposit
for
it
that.
before this court.
I'm saying that
Yes,
you may deposit 50% before the registry,
Lordship.
but we're
Lordship,
not going to pass any
may
order
not,
of
may not.
withdrawal.
Yes,
Okay,
yes.
and then subsequently
Yes.
they may
It will
file a
outcome
petition. In
outcome
that
of the
case,
appeal, Lordship.
we may
No,
hear the
no.
matter. What you want to submit
Yes.
before, as if the matter is sub judice or pending before
Yes,
the
yes.
honorable. Supreme
Lordship, may I pray one thing? 50% along with interest, Lordship. Otherwise, that 50% interest, they will not pay that out, Lordship.
It will be
It
paid
will be calculated
along with the
How can
final
we-
amount, Lordship.
I same with you. And so. It's an application for stay of judgment and related party. It was by Learned Member MSCT number M in MSC case number 577 2015, avoiding some of this 90 lakhs 244 together with 9% interest per annum with the above filing of the evidence. Considering the submission made by and counsel for the appellant, that the operation of the judgment and award dated so and so be state subject to payment of 50% of the imparted before the registry. For the registry. With the above observation, the present I is tested. We are disposing this I, you file an I
Obliged.
for withdrawal. We are not passing any order of withdrawal.
Lordship, Lordship.
Obliged. Number 6.
Please use your lordship. This is a statutory appeal. In this case, we adduced, insurance company adduced evidence that the driver did not have any driving license. But the court has mentioned about the evidence, but not given any reason
whether it is accepted or rejected and pass the judgment. Also. So we are basically on that, and on quantum also. mm, that there was contributory negligence of the deceased because he was also driving, and also about the interest lordship because during COVID also the interest is given. So there is other ground.
Parties are to be learned. Council to be approved. It's an appeal. Section 173. Against the judgment and award dated 19/5/2025. By learned member MSCT. Number 1, Kamrup M. Guwahati in MSC case number 514. It is submitted by MS Mujumdar that present appeal has been filed challenging the validity of the driving license as well as quantum. Appeal is admitted. Issue notice to all the respondents to speed post. Also called
Lordship, usual process because speed post lordship, no report will come. That is the problem. Usual process, at least the report will come. AD lordship, AD used to come back. Now this speed post is creating a bit of problem. So lordship, let's take it as usual process in the first instance. Tracking is also 3 months or 6 months, something like that. But beyond that, they do not have any record. They do not keep any record.
Okay. Usual. Usual. Also called for the DCA. The matter for
LCR lordship.
LCA we call.
Highly obliged.
May I please, Your Lord. This is an appeal against the order and judgment passed by the MSCT Court, Chirang, Kajalgaon on 26/11/25 against the order of the Learned Court for enhancement. And my lord, moreover, the amount has been imposed upon the owner on the ground that driver had no license but capital law is that Rambabu Tiwari United Insurance and the Saran Singh, National Insurance Company Saran Singh, 2004, that their first liability has to be disposed of by the insurance company, then to recover from the owner.
So you are the claimant respondent.
I am the
Claimant.
claimant. I am the claimant, madam. So my prayer the notice may be issued, madam.
Administrative and the council. Then appeal under section 178. Against the judgment and award. Dated 26/11/2025 passed by learned member MSCT Chirang Kajalgaon in MSC case number 81 of 2024. 24, basically challenging the quantum of the maintenance.
10,84,300.
The maintenance has also challenged. The award, which was directed to be satisfied by the owner of, and appeal be admitted. Appeal is admitted. Notice be issued. All the responses to speed post and usual process, and also corporate. The matter is
Diploma.
In this case, lordship, appeal is filed by the driver lordship. Involved vehicle had no valid policy lordship.
You are the
Driver of the involved vehicle. The driver and owner are held liable lordship. So our submission is that being a poor driver lordship, we are not in a position to pay. If any liability is imposed, that owner will have to pay lordship. Now owner and driver both are held liable to pay 50% of the added amount. They had
so
no.
you made the owner here as a respondent?
Yes.
Number two is the owner of the vehicle.
Yes.
Hardster AJ Saikia, Dealer This is an appeal under section 172 against the judgment and awarded 3-9 by passed by member MSCT import in MSC case number 29 will be issued also for the matter takes step. We are listing it after 4 weeks, and the TCR is also been
We will take step by usual process. Obliged.
May it please your lordship.
yes.
Your lordship, in this case, we are supposed to file the condonation petition as well as the stay petition, your lordship. So, your lordship,
Simply adjourning it.
yes, your lordship, it may be
Right.
taken up immediately after the review vacation, your lordship. In the meantime, we shall file the applications.
Considering the submission made by MSP Water and Council for the matter is adjourned. Let the matter be accordingly listed immediately after vacation and immediately listed. In the meantime, you can file.
Yes, your lordship. Obliged.
Can I get a defective facility? Condonation or defective facility? Can I get your nasa submission? Delay to the assay. So online. Yes.
This is also a statutory appeal. In this case, the court allowed for pay and recovery, but without following the process lordship that the owner will be giving security and also on quantum loss. And we have a stay petition also lordship. We can deposit, but that may not be allowed to be withdrawn.
It's a date case.
Yes, lordship. No, it is a injury case.
Injury.
Injury. Compensation granted is 1,80,258.
Was by London City. Bought back up in MC on 540. This is submitted by MS they basically dependent file challenging the quantum as well as the order of pay and recovery passed by the learner. If it is issue notice all respondents also for the matter. You have a I also.
Yes, lordship. 13 of 2026.
Same order for recovery 50%, payment subject to payment. So same order. Allow for a to need. Withdrawal to need. We are going to state the matter subject to payment of 50%. We are not passing any order of it.
Within lordship, we'll give the time.
Yes.
Within
Within 6 weeks.
6 weeks. Lordship, usual process step.
Yes.
Highly obliged, lordship.
I'll go to 6 weeks for you. Okay.
Hello.
On hearing item number 11.
After something, I'm going to the NCR.
Present. And then you just want to go through the case record.
The TCR has come, Rajat, this year.
But as soon as we have completed this, then just let us inform so that we can inform the other side.
Well, I have only one query, my lord. Defense cannot go through the record as Portmaster as inform us.
What?
Defense side cannot go through the as
No, prior permission. Actually, what had happened, there are some incident most probably had occurred. So that is why this kind of things are there. Otherwise, we are not, disallowing anyone to see the record provided in the courtroom itself.
where
Yes, yes.
we can
But
see in the
still, permission is most probably required. You can peruse the record, no issue. You can peruse the record in the courthouse.
obelisk.
Products. For hearing order protocol. Item number 12.
Item number 12.
May I please, Your Lordship? An appeal under section 100 the Code of Civil Procedure challenge the judgment and decree dated 35/2025, Lordship, passed by the learned civil judge senior division Golaghat in title appeal number 2 of 2025 dismissing the said title appeal by not interfering with the judgment and decree dated
So that means
31/12/2024.
it was a concurrent decision. Concurrent decision.
Yes, Lordship.
Dismissed.
Dismissed, Lordship.
The suit as well as appeal was dismissed.
Actually, suit, Lordship, suit was filed by the respondent, Lordship.
Oh, you were the defendant there.
Yeah, I'm defendant in the title suit, Lordship.
So then what? Earlier suit was decreed.
Decree, Lordship. And what happened, Lordship, the appellate court, due to wrong calculation, came to the conclusion that there is no question of devolution of any land of Suddak number 429 to the successor of the late Satyanarayana Sahu. Although they have 10 a plot of land 10 lisa is still there, Lordship, but in page 54-55, Lordship.
54.
Yes, Lordship. Second paragraph, Lordship. On perusal exhibit 2, it is found that Satyanarayana Sahu purchased 1 bigha 11 lesa land in Suddak number 429 from original Pattadar Isan Napit, Lordship, as revealed from the antedated 15/7/1967, Lordship. Enters in exhibit 2 further shows that subsequently by order dated 36/1990, land measuring 1 kotha 4 lesa of Suddak number 429 was acquired by government by bordering the road, and the said land is carved out from the aforesaid duct. Lordship, total land measuring 1 bigha 11 lesa. That is, Lordship, total 111 lesa land, Lordship, and government acquired, Lordship, 14 lesa. And subsequently, Lordship, on 25/4/2012, land measuring 1 kotha 7 lesa of Suddak number 429 was purchased by Sri Naresh Agarwal and Suresh Agarwal. That means, Lordship, total 27 lesa purchased by the.
Otherwise, also you can calculate 1 katha, 2 katha.
Yes, Lordship. Page
1 katha,
5, Lordship.
2 katha.
Page 5 of our plan, Lordship.
One in one hand, 1 katha 4 lesas, another one that 1 katha 7 lesas.
Yes, Lordship.
That means 2 kathas 11 lesas.
Yes, Lordship.
So
And
your total
there-
land was 1 bigha 11 lesas.
11 lesa. And thereafter, Lordship,
So in that case, here remains again 3 kathas.
10 lesa.
Huh?
10 lesa already remains. We have, Lordship.
So again one.
Again, Lordship, again on
10 lesa.
5/7/2014, Lordship,
Sir.
the plaintiff purchased remaining 2 kotha 10 lesa.
But then 4 kathas 22 lesa. 22 lesa.
Total, Lordship, 1 bigha 11 lesa. That means
No, yes.
111 lesa. Total. And thereafter, Lordship, got acquired.
111 lesa.
Yes. got acquired 1 katha 4 lesser. That means 14 lesser.
So 20 lesser already gone 5 katha. 5.
Thereafter, Lordship, 1 katha 7 lesser sold to Noresagar and Suresagar. That is,
20 lessers মানে 5 katha 2 lesser.
Lordship, 1 katha is equal to 20 lesser.
20 lesser 5 katha 2 lessers.
Yes, Lord.
You know, 5 katha 2 lessers we go there. Actually, 9 lessers ring.
No, Lordship, 10 lessers. As per
But
my
9
calculation,
lessers.
Lordship, 1 bigha is equal to 100
Yes,
lesser.
yes, 10 lessers ring.
Yes.
Yes, right. 10. So you
But-
want to say there was a wrong calculation.
Yes, Lordship, that in the last pickup, Lordship, that it is seen that after the sale of 2 katha 10 lesser by the land by Satyanarayana Sahu to the plaintiff, he, Satyanarayana Sahu, was left with no more land in the suit, that Lordship. And now the judgment was passed by the appeal also, same order, Lordship, they evicted the plaintiff, Lordship, from the land.
So where is your any substantial question you have already framed here?
Yes, Lordship. Page 7, Lordship.
Page?
7, Lordship. Page 7 and 8, Lordship. And Lordship, the earlier advocate, Lordship, he had not cross-examined the PW1, Lordship. And he had no information to the present appellant to that they have any dismissal order, any appeal he has filed, Lordship.
So then,
That's why we have,
but you have filed the appeal.
yes, now we have,
No, here, not here.
Yes.
First appeal you have filed already.
yes.
Why you are saying that it is barred by section 6?
Yes,
How it is barred by section 6? Your first substantial question of law. How can you say it's barred by section 6?
Number 1,
Yes. What is section 6?
actually, Lordship,
Section
we have the right, Lordship, the 10 lesser only remaining plot
No,
of
sir,
land,
it
but
means
at
what?
the, and
Why section 6? I am saying why section 6 is there. For your first substantial question of law, you have mentioned this section 6.
6, Lordship.
Which is how?
The pecuniary jurisdiction, Lordship.
Yes. How it is already been entertained. So, was there any issue? Was there any discussion in regards to your pecuniary jurisdiction? Because your both the cases have been tried by the learned trial court
Yes.
below.
Yes, Lord.
So how this section 6 question of section 6 will come? It may come when the issues were framed and it is suppose the order was passed that it is barred by pecuniary jurisdiction, maybe sometimes. But here too the question doesn't arise. Number 1 is gone. Number 2, what is this?
Whether without,
Lack of cross-examination, that is your fault. You did cross-examination, that how can court help you now? Number 3, what is the number 3? Yes.
whether the appellant court has properly calculated the entire plot of land in suit doc number 429, Lordship. The measuring 4 quarter 7 lesser because out of total land, a plot of land in 1 quarter 7 was sold to the another person. So order dated 25 to 2012, Lordship. And whereas the appellant has remaining plot of land measuring 10 lessers, Lord. However, did not appellate court decide the where there was no more land to the
See, these are all on facts. What your law points, in fact, no law points at all.
Lordship, the law
Because
point,
that
Lordship.
is a concurrent jurisdiction.
If Lordship,
isn't it?
if Lordship the
Both the learned trial court below had arrived at a concurrent decision.
yes,
Your the plaintiff suit was decreed, your appeal is dismissed. That is the concurrent findings. So there I cannot find any
Lordship,
substantial question of law.
Lordship,
These
entire
are all
plot and
facts.
Lordship, eviction order is an entire plot, Lordship. The initial order, Lordship, in page.
One thing, yeah, I'll give you a time, some time.
Yes, Lord.
It will be listed after review. If you can frame any other substantial question of law, please try to frame it. Because if I go by the substantial question of law, we have already formulated, there are 5 numbers. But all these substantial question of law, 1 and 2 had already gone, there's no issue at all. Number 3 and 4 also, it seems that is on fact, not on the law point. There's no law point at all. So just try to get formulated. We'll see to it. Any other substantial question of law, if you can formulate.
Yes.
Well, this part will do by the okay. Sitting this submission, you are Mr.
GG Google.
GG Google. Sitting some made by Mr. GG Google, done also for the appellant. Matter be listed after review vacation, and nothing the counsel for the appellant to frame any other substantive question. If
Lordship, after 27 January, Lordship.
I'm just saying that after vacation, so it may come after vacation. May not be before 27. It may be after 27. Or we can pass it the last week of January.
Yes, Lordship.
In that case, it will help you last week of January.
Last
Maybe you will listen last week. After vacation, it will come. And no issue.
Does item number 13.
May I please, Your Lordship? Respondent has already withdrawn the family court case. Lordship, the present case is becoming infractions.
Already withdrawn.
Yes.
I mean, this transfer petition filed by you, what matter was pending? In fact,
Lordship, it was pending for
no, it was a divorce matter or what?
a transfer matter.
No.
Oh,
Original
yes,
case is
Lordship.
a divorce
Like
case.
restitution of conjugal right.
Restitution of conjugal
Yes.
rights. It is filed by the respondent.
Yes.
He has already withdrawn.
Yes.
You are MS?
P deca.
MS?
P deca.
MS. You are for the whom? For the plaintiff?
Respondent.
Achha. You are for the respondent?
Yes.
How can you submit then? Where is the petitioner?
And Lordship, in this case, I am the respondent. In family court, I am the petitioner.
Whatever, you are the petitioner.
No, Lordship, I am here.
You are the respondent.
Yes,
So
Lordship.
petitioner had filed. So let them come, let them inform.
Okay, Lordship.
Can you meet the other council today itself?
No,
We can
Lordship.
pass the order then.
No, Lordship. I will contact.
The submission should be come from their side. No? That's why. You are for the respondent only?
In this case, I am the respondent.
Yes, they have filed the transfer petition.
Yes.
I know, no? Okay, no one represented and appears on call for the petition. However, hard MSP the learned counsel for the respondent who apparently submitted that they have already withdrawn the withdrawn the case from the learned court, from the concern. This is the matter immediately after vacation. On the next day, suppose if you can somehow meet the other council, just let them inform, that's what they can get.
Okay.
May I please, Lord?
Yes, Mr. Yes.
In this case, service has been completed as per the report of the registry. Matter may be fixed for admission.
It was a sole respondent, no?
Shoulders.
Rajma court order.
Lama Deva has authored.
You are the wife.
Yes.
Heard Mr. Anand from the report of Raj Court. You see that a services notice is deemed to be served on respondent, sole respondent. However, no one has represented the respondent. Was any interim order was there
Yes.
in the office? Let the matter be listed for hearing and immediately after vacation and interim order granted earlier. We're going to hear the matter after view vacation.
After?
You want any fixed date here?
In
After
the,
view vacation,
yes, in the month of February.
the month of February. February month.
Any date?
17th of February will do.
17th.
1/7.
Lovely.
May I please, your Lordship? It's a very small matter, Lordship. The matter will be disposed of today itself.
Lordship, the matter was supposed to be listed in the admission column. However, due to inadvertently, it has been listed in the orders column.
So you want to submit anything here today or what?
My lord may fix a date.
Want a date here?
Yes, your lord.
However, it's a very small matter, Lordship.
You are Mr. Sharma.
Yes.
You are Mr.
Yes.
R.
yes.
Sharma. Mr. R. Sharma. MS.
J. Sharma on behalf of A. Iqbal.
Everyone. A. Iqbal, this sole respondent will send.
Lordship,
Only one respondent or
there are three numbers of respondents, Lordship.
How
The
many?
respondent number 3 was struck off on the last occasion.
3 was struck off, then
The two service upon respondent number 2 is
still awaited.
no, Lordship. Process is served upon respondent number 2, Lordship. Can you
go
see
for
the last
respondent
order
number
date? Last order dated 9/4/2025, Lordship. Process upon respondent number 2 was served.
Served in a sense, yes, it was received by his daughter.
Yes, his family members. So as per order 5, Lordship, the process is
Should
complete.
be male member, I think, na? Male member, not the female. Anyway, who is he, in fact?
Pardon?
Respondent number 2 is how he is related.
Lordship, actually, the property in question was purchased by the petitioner from the respondent numbers 2 and 3.
Name of 3 has already been struck off. Putuli.
Putuli, sorry,
Putuli
wrongly,
is, wrongly?
wrongly Kumari, Lordship. Her name was struck.
Rongili Kumari has already been struck off.
Yes.
Putuli Bala Kumari.
Yes, Lord.
You know her? Putuli Bala Kumari?
Lordship.
You are Abani Kumar Das.
Yes, Lordship.
No, you know Putuli Kumari. Putuli Bala Kumari. You know her?
Lordship, there was some arrangement done between there was some arrangement between the respondent number 1, 2, and 3. However, we are not related.
Do you know her?
Actually, it's a we have filed this petition challenging the order dated 10/5/2023, Lordship, in the execution proceeding. In that execution proceeding, the present petitioner has filed an application under Order 21, Rule 97/103, Lordship. in contrast to the order passed in our petition, there is an order, impugned order in the execution proceeding.
Harsh Hirani. 15. Yes, what your name?
Jay Sharma.
Jay Sharma, appearing Mr. A. Iqbal for the number 1. And from the order date 9/4/25, the services already already notice is already been served. Which is already been served to the respondent number 2. And the name of the respondent number 3 has already been struck. The case was ought to have been listed in admission column, but inadvertently has been listed in the order column. Let the raise to be directed. Raise the matter in the admission column on the next listing.
Lordship, interim order maybe.
Interim was there. Interim be continued in next listing. List accordingly on. You want any fixed date here or after?
In the month of February, Lordship.
10th of February will.
Obliged.
Much.
My pleasure.
Yes.
As per office, Lavazima Court's order dated 12/6/25, my lord, service is complete upon all the rest.
Lawajima report.
Yes, my lord, 12/6/25.
Two, 1 and 2A to 2D.
Yes, ma'am. One is the mother and 2A to D, they are the son and daughter of respondent.
You are Mr. M. Sharma or
HK Sharma.
Huh?
HK Sharma.
HK. Mr. HK Sharma done responsible. As per office note dated 20, as per the Lawajima report, the notice has already been served on respondent number 1 and 2 small a to 2 small. In view of this, let the matter be accordingly listed in admission column. Registrable to the after 4 weeks will do.
Ma'am.
List the matter accordingly after 4 weeks. Interim was there. Na?
Yes, ma'am.
Interim be continued.
Much obliged.
May it please your lordships. My lord, in this appeal is admitted, lordships. Appeal is admitted, and lordship, there is an IA, lordships. IA for payment of maintenance, penalty light, and expenses of proceedings, lordship. Lordships, I am the wife, lordship. Along with me, one daughter I have.
No need to worry about it. We are not going to pass any adverse order in absence of your senior. Okay. What's your good name? Your good name is what?
Prince Mohanto.
Huh?
P. Mohanto.
P. Mohanto. RMS P. Mohanto. Appearing on behalf of whom? You are appearing on behalf of whom?
D. Bora.
D. Bora. The Learned Counsel Petition. Third, you are Mr.
BP Sharma.
B.B. Sharma, appearing, your sole respondent,
Lordship.
appearing for the sole respondent. However, it is submitted by him that today morning itself, they have received a notice and they are yet to file their bakara. Let the matter be accordingly listed. It LCR is done.
After
Let the matter be listed accordingly. Yeah, all quotas. Policy. Scan for listed after 4 weeks as on a date to be fixed by the registry in the admission column. And further, if the registry is hereby direct issue reminder for TLC, for the TCI list account. Sorry, interim at interim be interim, no interim. No, interim.
Deeply blessed.
My lord, here we are going to file objection today, my lord.
In IA.
Yes.
What is the IA about this condemnation?
Condolence delay.
2,211 days. my lord.
But Corona period is not minus. Corona period will be less.
Corona period.
Corona period.
But we have
3 years.
But your week started from before Corona or after Corona?
Before Corona.
Before Corona.
Corona period should be deleted by the Honorable Supreme
But
Court.
your one is before Corona, I think. During Corona, it will be deleted. But your one is before Corona, after Corona.
This order was before Corona, Lordship. But I filed after Corona. So that should be deleted, Lordship. That is not deleted.
We'll see. Heard Mr. A.R. Agarwal, the Learned Counsel for the applicant appellant, and also heard M.S. L. Sharma, the Learned is submitted by M.S. Sharma that they're going to file their written objection.
They have not filed in Lordship yet.
No, they're going to file.
ready.
File this
Earlier date was also given for filing.
Let the matter be accordingly listed immediately after vacation, due vacation, enabling the respondents to file their written objection. Yes.
Oh, bless me.
25.
My lord, before starting my learned friend lordship, I was the respondent lordship in the main case lordship, but in the case they have taken the file lordship. So I cannot appear in the, though my name is shown because of which I appeared before your lordship, but I cannot appear in the IA lordship because I have no such instruction, whatever my lordship, they have taken the file lordship, original record from me.
Taken back your file.
Lordship.
My lord, only some correction of last line, my lord, some mistaken. I have served the copy, but he refused, my lord, that I cannot see, my lord. Kindly come to the last page, my lord, last line, my lord.
Last page, last time?
Last line, my dear.
Which last time?
My lord, of the IMA.
What? Last line of order, last
Order,
line
my lord, order, my lord.
Lord.
My lord, the main case was allow rejection of amending WS.
Correction. Yes. I'm not following. It was disposed of earlier.
Yes.
Yes, my lord. I have filed for only for my lord this my lord correction of typographical mistake perhaps my lord. I have filed the IA kindly page 26 my lord, of the IM.
Melody, this last line shows lordship, it is a very reasoned order, lordship. My learned friend, already we have objected on that point, lordship, before the learned court below. Only petitioner filed the amendment petition. It cannot be. Your lordship's order is very much correct, lordship. So there is no such question. As I have collected it from the net lordship order, it's very reasoned order. However, the amendment written amended written statement may be accepted only if it is jointly filed by all the other defendants also, lordship, which we have objected and before your lordship also. My objection was on that line, lordship. Only one person filed the amendment petition. How it would be, lordship? Other, they have jointly filed their written statement, lordship. So that may not be. It's amount to
Now
review.
you want the correction
May
where?
I make my submission, my lord, before my opposition has come fast, my lord.
No. Just
lord.
I am apprising this honorable court.
My lord,
It's amount to a review, lordship. If this lordship correction subject to lordship, my respective submission before your lordship, it will amount to review, lordship, which is not very reasoned order, lordship. There is no such things required to be corrected as my learned friend has filed the petition. While filing the petition in there, before that they have taken the file, but last night I have collected it from the net, lordship, and orders. I have gone to the order, lordship. Very beautiful. Specifically mentioned by your lordship that however the amended written statement may be accepted only if it is jointly filed. Because they jointly filed the written statement, lordship. How a single person can file an amendment petition, lordship? All these things are done, lordship, by them, correction of deeds and everything. And now he is my learned friend. Why? What is the objection there, lordship, to file joint written statement? So that everything will comes out, lordship. How this correction of boundaries and everything will happen.
Okay, now you are ready for hearing today or what to do?
Lordship.
Now you have submitted that you have your file has been already
Lordship,
taken
lordship.
back. You need some time for hearing this.
Lordship, because I have no correspondence connection with them, lordship, for which lordship, I submitted as an officer of the court, lordship, I should have to assist because my name has shown, for which I came before your lordship.
No, on that basis, suppose the order of this, if you can, we can provide you the this copy, so you can go through. Or if you want to appear, in that case only I'm just asking.
Lordship, at
Then
this stage,
yeah, can-
lordship, without wakalatnama, I cannot, lordship.
Oh, you have
Because-
not entered into your appeal.
Lordship. Because I have no wakalatnama. Earlier wakalat case was there. My learned friend came with a correction, lordship, after disposal of the case. And lordship, they have taken the file without getting my wakalatnama. How I have no right to say, but
So we
for
are going
the
to
officer
issue
of the
notice in that case.
My lord,
let a notice may go,
my lord, kindly, my lord, before, if my
No,
learned friend is completed, my lord, learned is completed, my lord, I may be allowed to.
No. We are not going to hear the matter. We are going to issue.
No,
the
my lord,
notice only.
perhaps not required, my lord, but kindly hear me, what is the,
Going to appear, how can you say now?
My
What,
lord,
what do you want to submit?
my lord, kindly see.
It is a case of, so far I can understand, it may not be a simple case of correction.
lordship.
It may not be a simple case of
Yes,
correction.
correct,
It may be a case of review itself.
Perhaps your
Yes.
lordship,
In that
my lord,
case, we have to hear the other side. There can be
if I make my submission, maybe your lordship will be satisfied, my lord. Because
There's a
some,
question of
my
satisfaction.
lord, government employees also there, my lord. How can I ask the sub registers to file WS, my lord? Even the officers are also there, my lord.
Earlier, all the family members, you have.
Yes.
No, my lord.
We are not.
No, my lord.
asking you to
This is
file
not,
jointly
my
with
lord.
sub-register.
My learned friend is not correct, my lord.
Lordship, record is, I think, already returned back perhaps. Let a notice may go, let the party
Only
appear
to
and
harass
everything
me,
will
to
show,
delay me,
lordship,
only this is the way, nothing more.
No, nothing delayed, lordship. We are interested to finish up the
It
matter,
is missed.
but not like that way, lordship. Because subject to correction, so far I remembered, lordship, because all the other persons, those who are on power of attorney, they have made some correction of the boundary and now came with that amendment petition by this petitioner without taking them, and as well as they have filed a written statement jointly, lordship, for which there need to be filed a written amendment petition jointly, lordship. Otherwise, how it would be, lordship? It will amount to violation, lordship,
My
and
lord,
lordship,
may I be allowed to place my case, my lord?
deprivation of
No,
justice.
we are not going to hear.
My
the
lord,
case.
40 and 44 is government officials, my lord.
Whatever may be.
Even, my lord.
Government official not yet filed the Because the private respondents, they have
File
filed their
any
written
WS with
statement.
you.
How can I compel them to
They
come
can
with me, my lord?
jointly file any WS with you.
Yes, my lord.
Oh.
So how can I
Yes.
compel them to bring with me to take to file a WS with me, my lord?
That is not a question. The WS which has been filed jointly by you all. That is
Yes,
the question.
correct.
Exact, my lord.
Now the
Again,
sub-register is
again,
not
my
in-
lord,
not
my
in
lord,
picture now.
my lord. Again, says 18 to 39. They are my opposite party, my lord.
So what? Lordship, they have
We have
filed
to go to
jointly.
opposite party to file the
Only
WS.
now he is coming with the filing the petition, Lordship, for
And
amendment.
my lord, it will
Lordship.
take again few years, my lord, to solve all the my lord notice on all of them, my lord. My lord, they are living in different districts
No,
of the.
Earlier you were
country, my lord.
appearing for whom?
As a respondent number 1, Lordship.
One.
1.
Let one and how many respondents you have cited?
My lord, there are total 44, my lord.
Because they support them, Lordship. I am not, I entire case is against me, Lordship. I am the interested beneficiary of that, Lordship, for which, with all respect, I am submitting. I have my categorical submission in there in your judgment, Lordship, this honorable court judgment, that how the things was rejected by the learned court below. Once they filed a joint WS, Lordship, how a single person can file a written amended petition, Lordship, amendment petition? Correctly, Lordship has passed this order, Lordship, last line. And if any correction is required, Lordship, this will amount to a review, Lordship. This will
My lord,
amount to a review,
typographical
Lordship.
mistake only, my lord, bias,
It is
my
not
lord.
a typographical
Because, my
mistake,
lord,
Lordship.
opposite party,
it's
all the
not a
opposite party, my lord, are asked to file, my lord.
Not a type.
All the opposite party, my lord. How that I can compel the defendants, my lord, my opposite party, sorry, my lord, the complainant, compel them to come with me, my lord, to file this.
Those who filed the written statement before the court below, Lordship is correct on that, Lordship.
Right,
Last line
kindly come to the
indicates.
plain copy, kindly come to the plain, your lordship,
Mr.
everything will be
K.
clear, my lord.
Majumdar, the learned counsel, the petitioner, and also heard Mr. K. Majumdar, K.A. Majumdar, the learned counsel, respondent. It is submitted by Mr. Kalpa that it is a petition only for some correction of the order which was passed at this court dated 10/9/2025 in connection with CRP IO number 183 of it. Next, Mr. Majumdar submitted in this regard that after disposal of the said petition, the party has already taken back their brief from him, and now he is not in a position to appear on their behalf, and he needs some time to consult with his client and to file his file. In view of this, a press notice be issued to all the respondents, and Mr. Majumdar is also hereby asked to make communication with his client so that he can appear in the case on the next date of listing.
Lordship, let a notice go to my client also.
Otherwise, I have passed
Lordship.
this order.
Because I have very categorical in my submission, paragraph 9, Lordship, page 9, Lordship. It is submitted by Mr. Majumdar that the defendant number 1 to 17 jointly filed the written statement. Once they jointly file the written statement, what is the harm to file their amendment by jointly? I am not others, Lordship. Everything will come out, Lordship.
How can I compel the opposite party, my opposite party, to come and to
So what?
and the government officials?
You are able to
How
make
can I?
a amendment, make a
Then in that case,
correction.
we may make a clarification regarding that the joint written statement with the government officials is not a question.
Not done. Government official has
And
not filed
also,
jointly.
they, my lord, the plaintiff, except me, minus government officials, all of the same family members. How can I compel them to, my lord, to file the WS?
All others, if all
With
they
my
are the
lord.
parties
Earlier,
put the
1
court.
to 17, you have jointly filed your WS.
Yes.
My lord, through their power of attorney. My lord, how can I compel others to come with me and to file my lord WS? I
Not
cannot.
power of attorney, Lordship, it is there already, I think, in the record. Lordship.
If you want to, now the question is, another question is there. If the case is delayed, in that case they are going, they will not be able to file their written amended this WS.
Lordship.
In that case, the case will ultimately be delayed for both the parties. So ask your party also to appear before the court so that one order can be passed. Maybe
Lordship.
clarification maybe.
Lordship, I'll write a letter to them, Lordship, because I have no phone number now, it is Lordship, for which.
You are going to issue notice.
Lordship.
My
you
lord,
also-
one thing, my lord, can be done, my lord, the on plaintiff, my lord. Notice may go. Only one plaintiff. My lord.
So and those who have jointly filed their return statement, lordship,
lord,
they
I
have
don't
not
know
come,
why my
lordship.
learned is trying to delay
Yes,
an
they are the
answer.
petitioner before your lordship.
After vacation we'll do or after 4 weeks?
Lordship, because needs for report from the for the service of notice,
After
lordship,
4 weeks as an edit.
because I am the respondent. Lordship.
My notice on whom, my lord?
You have made your respondents.
All the respondents, my lord.
Officially to if all the respondents.
My lord, the main party is
You have
the
appeared already.
complaint party is the main party.
Just a second. 40 to 44. 40 to 44. The government advocate. You are MS. Additional senior government advocate. So Burma, MS Burma has already entered into evidence for respond number 42, 43, and 44. Only 44.
40244, my lord.
43, 42.
40244, my lord.
40, 41, 40, and 40 to 44.
My lord, notice may go only to the main party person, the Moinuddin, my lord, main plaint, my lord. Plaint, my lord.
Because
26. May I please, your lordship? Lordship, can you have a look the I application 3709. At 3709, we have filed instant application, my lord. In violation of this 15/9/2023, the already this honorable court has admitted my second appeal, although state the proceeding of the impeachment. Despite the state, my lord, the respondents plaintiff, my lord, the permanent construction is being carried out, my lord. So where before this court, this I, my lord, let them be complied, strict complaints of this earlier or stay order passed by the honorable court, and whatever construction they have carried out, then may be straight, my lord. I, my lord. Page 9 is the order. Page 9, on 15/9/2023, this honorable court has admitted this appeal, my lord. Then lordship will find, my lord, at page 12. I, that is next year B, page 11, my lord, I number 27/2/10/2023. Lordship will find the order
Where is
at
this
page.
the order of state? You have said
Yes,
submitted.
at page 12.
Page 12.
12, yes, my lord.
Page 12 for?
In I, my lord. 370925 I. It's here. Hearing is fixed right. And that is the 15/9/23, my lord. And paragraph page 13 is the state.
This order of stay was passed in which the appeal itself or any other I?
No, this is separate I, my lord. In the may admitted my second appeal. This is separate I for stay, my lord. In the state, my lord, same date, my lord, state.
IA civil 2723.
Yes, my lord.
Achha.
2723. Yes, my lord. And then from my lord, records call for state the proceeding, my lord, and lordship will find.
What is the position? They are now.
Well, page 14, NXRC. Can you have a look? Over the suit line, my lord, the plaintiff has filed a suit of specific performance over the death suit line. This permanent structure in carrying out, my lord, though there is a stay of this court. So my humble submission, my lord, let them be strictly followed the interim state, state passed by this honorable court. If the LCR received, my lord, in the month of February, this matter may be fixed for final hearing, my lord.
LCR received, my lord, I have read.
And let them strictly followed this interim step by the honorable court. No more further construction be carried out. That is my submission. If any construction being carried out. Okay, I understand.
Now it's one kind of, I don't know. Stay is there, now they are constructing. So
Yes, my lord.
No, my lord,
Despite this stay order, they are constructing, my lord. This is absolute violation of this order, my lord.
The thing is that the suit was initially filed by us. We are the plaintiff. That suit was dismissed. Yeah, it was a suit of specific performance, my lord. Thereafter, we filed appeal, first appeal. That was allowed. And the appellate decree was that, my lord, that the defendant will execute a registered sale deed in our favor. Now, there is no primary injunction as such. Originally, there was no injunction. Then the appellate court simply said that
executed.
registered deed. So there is no injunction. So what stay has been granted in the RSA matter, that the judgment passed by the appellate court. There is no case of injunction, and then the defendant has also no prayer for injunction in the over the suit land. So that
But the question is that if they were asked to execute a sale deed in your favor,
yes,
but you were already in position of
yes,
consent.
since 2011, I have gone through the plane.
You were already in position.
Yes, I have gone through the plane. The plane says that, my lord, just after taking possession, the plaintiff had started construction of various houses, including residential houses are also there. So it's not a vacant land as such. So, my lord, since it's a prayer for injunction, my lord, my proposal is that either lordship may finally hear and dispose of this RSA, my lord, or my lord, I may be allowed to file an objection in this injunction petition.
That's what. Otherwise, it is not a case that you are strict compliant.
My lord,
But the
admittedly,
question
my
is
lord,
that it's a kind of
first of all, my
injunction,
lord,
in fact.
this honorable court had it's a reversal findings, my lord. The second appeal admitted against reversals findings, my lord, and this honorable specific in the I state, my lord, the findings of the learned appellate courts below. That means, my lord, whatever the findings made by the appellate court is
Now,
by
see,
the
there are
state
two
or state, my
different-
lord.
Question is that obviously the operation of that stay order passed in the first appeal was state.
State, my lord.
Isn't it? So for that,
Yes, my lord. Yes, my lord.
But the question is that as per them, I don't know. As per them, they are
Since
already
the
in
disputed
position.
land, my lord,
No. They were already in position. So
whether
you
they are
were- you
already
were
in possession or not, my lord, it
No,
will
no.
come on the merit of the case, my lord. On
Definitely,
yes.
definitely it will come. But
Yes.
you were only asked to execute the sale deed in their favor. That much only. There was no such order of that injunction or stay or whatever. Now the question is, stay is on what aspect? Stay is there. Stay is now to stay
Regarding-
is also a question of a bit confusing question because you were asked to execute the sale deed.
That is the
So
question
that-
involved, my lord. That is the
yes,
on
that is-
that
that
point
is stay.
substantial question law admitted by this court, my lord.
Definitely, that is
And
stay.
and my
Now-
lord, all
now if you-
the
if
suit,
you
my lord, they are claiming for execution of the sale, registered sale bill over that land with a dispute under the question, my lord. And this already the trial court has passed judgment in our favor against the appellate court has reversed their finding and this way before this court, my lord. And this one I will admitted for question of law. State this road during pendency of the how they can construct that over that land, my lord. After second appellate court is appeal the findings of the appellate court, then the question they can carry out any construction there. How they can they got authority to construct it. So my humble submission, you know, they strictly complied this honorable court's order, and lordship may fix the matter in the month of February for final hearing, my
But
lord.
was there any stay order of injunction, etc.? They not
Regarding
in
not
your-
not
Yes,
no,
no such order.
our only
It is the first petition where you know seek
Oh,
for
our
injunction.
only submission, lordship, we have seen the Milord, my paragraph number, Milord,
No,
5 and 6. Can I have a look my application?
No. I can understand. The question is that your stay was there, undoubtedly, no issue at all.
My
So
lord.
second appeal, you have filed an I.
My lord.
The order of the first appellate court was stayed.
Milord.
But the question is that the position of the land, disputed land, there was no question at all because it was a simple order for execution of a sale deed in your favor. Sorry, in their favor.
In their favor.
So now you're for the first time you're seeking injunction, saying that they're constructing constructions over there in the permanent construction over that property, which is a disputed
Dispute, yes, my lord.
disputed one.
Yes.
Now this is a one, let's say not a case of strict compliance of the stay order, but it's a case of injunction itself.
My lord, it is the application we have filed.
Let them file their WS or matter may be heard.
Yes. Well, otherwise, if they carry it out, if the permanent structure and carry it out, then what will happen, my lord?
Then we'll give a
No
very short-
permanent.
we'll
Some
give a
observation, lordship, some observation.
Let them file their objection. We'll give a short date.
Yes.
Very short
After
date.
vacation.
Immediately after
after
vacation, we'll give a date.
Yes, lordship.
Immediately after vacation.
Up to your lordship, my lordship, any date, my lord, we're ready. My lord, if the in the meantime they carry out, my only submission, my lord, no more further.
7 days, a matter of 6-7 days. we are-
Yes, my lord. No more further permanent construction will carried out. That much observation I'm carrying, my lord. Otherwise, my lord, what will remain, my lord, in my second appeal?
Then that
And
22 is a hearing day.
22.
Let it be on
27.
No. 27 will be much delayed for you.
21?
My lord, I respectfully submit, my lord. Since this honorable court is
21. Realistic it on 20. Very
21.
short.
21. I'll
My
file
lord,
it on
my-
20. I'll file it on 19. I'll file my objection by 19.
A restraint may be directed to place in record, my lord, that the affidavit filed by the, will be filed by the intermediate of the defendant, same may be placed on record, that may be directed to restraint, my lord. Otherwise, it will not come on that date.
A date may be fixed for filing.
Okay. Or Mr. Pickett, Tilan, possibly. Pickett, or Mr. Esther, Tilan, Mr. Das, Tilan, possibly. Wait some time to file the written petition. Prayer out. Is the respondent will file the written objection by 19/1/2026, and matter may be and the said in the objection may be brought into record of the next date of listing. List the matter accordingly on 21/1.
That's all. That's
Yes, you have gone through, Miss Nargis, you have also gone through the record?
Yes, madam.
No, we
I
have
wanted to say only
the permission, the question of permission. I'm also not personally so agreed with it, but the question is that there were some issues raised earlier. That's why this we have to make some strict compliance. Otherwise, no issue.
Madam.
Anyway. Yes.
My lord, it is earlier rejected by the Honorable Court. The petitioner was shown arrested in this case on 16 to 2023.
Yes, till us 16
to 2023.
Shown arrest.
Shown arrested. So, my lord, he was earlier arrested in a case pending before the CGM Amingaon. It is in the record in the page number.
Arrested on which date? Can you tell me?
My lord, he was arrested in Amingaon Lordship.
Whatever.
My lord, Lordship will find it page number 27. In page number 27, he was produced before the CGM Amingaon. Then, my lord, on that day, petition was moved by the IO of this case. A production warrant issued by the Lanet CGM Kamrup Metro, and on the basis of that, Lordship, he was wanted this case. That is why, Lordship, he produced the warrant before the CGM Kamrup Amingaon. Then, Lordship, he was arrested in this case on the basis of that production warrant. Lordship, in this case, I would like to earlier occasion also I made my submission in that regard, Lordship, that Lordship has passed an order that as my learned friend has submitted earlier that section 50 and 50A was complied with. But Lordship, if we go through this order sheet of page number 27, Lordship, kindly see the second paragraph, Lordship. Third paragraph. Sorry, second one, the accused persons appeared physically fine. Seen the inspection memo, forwarding reports, and medical reports. The accused persons have been made aware of their legal rights, and accused Dibjyoti Nath stated that he has already engaged a counsel of his choice to represent him, but accused Haran Patgiri stated that he does not have the means to engage a counsel to represent him. As such, the learned counsel Jahirul Islam has been appointed as legal aid counsel for the accused Haran Patgiri. Inform learned counsel Jahirul Islam accordingly. So on that day, legal aid counsel was engaged, but nobody was present in that case when the IO has filed the production warrant before the CGM Amingaon. So, my lord, in the next page, in later on, order passed by the CGM, kindly see. Seeing the prayer of IO, so and so, has stated that accused Harin Patgiri is found involved in the instant case of dispute PS case number, so that means present case. So on 11/2/2023, a prayer was submitted before the Honorable Court of CGM Kamrup Metro to pass an order and to issue production warrant in respect of accused Harin Patgiri. And Honorable Court of CGM Kamrup Metro has pleased to issue a production warrant in respect of accused Harin Patgiri, fixing 16/2/2023 for production of the accused in connection with dispute PS case number 2479/2022. IO further stated that accused Harin Patgiri was arrested in connection with Mukalmua PS case number 42, section 700, and now he is under police custody of Sangsari PS case number so and so. Hence, IO prayed for passing an order directing concerned authorities to hand over the custody of accused Harin Patgiri and enable her to produce the accused before the Honorable Court of CGM Kamrup Metro for the interest of investigation of the instant case of dispute PS, and in compliance to the order dated 11/2023 passed by the Honorable Court of CGM Kamrup. So accordingly allowed. So thereafter, Lordship, next page is page 29. This is the present case. Here, Lordship, what happened? See the from the second paragraph. Also see in the prayer of IO for showing the accused person arrested in connection with the instant case, along with a prayer for allowing police custody for the accused for a period of 7 days. Peruse the forwarding report, notice under section 50, arrest memo, inspection memo, and medical report. No injury is noticed on the person of the accused, heard accused, learned advocate for the accused, and learned PP. So there is the main problem. So that is why, Lordship, on last occasion, I made a request before this honorable court to collect all the petitions and wakalatnama as if it is in the record, whether any advocate was present on that day or not, any wakalatnama was there or not. Accordingly, I have gone through. I think Learned PP has also gone through that thing, Lordship. I found that one wakalatnama 5 on 13 October 2023. That means it is reflected in the order sheet itself that accused he himself stated that he was not in a position to engage a counsel. That is why legal aid counsel was engaged on that day, and his name mentioned and directed to inform the court officers to inform the legal aid counsel, Mr. Zaharul Islam in Amingaon. So on that day, on same day, 16/2/2023, and on that day later on, the investigating officer of this case filed a petition with a production warrant passed by the Learned CGM Kamrup Metro as he was wanted in this case. Then he produced before this court on that day, Lordship, on 16/2/2023. How it is possible for the accused, if he is stated before the court that he is not a position to engage a counsel and legal aid counsel was provided, but he was not present, he asked the officers to inform the legal aid counsel. That means on next day. Next day. So, my lord, on 16/2 itself, on that day, this person was produced before the Kamrup Metro, CGM Kamrup Metro. On that day, how it is possible to engage a counsel by the accused, my lord? And why it is written, I don't know, my lord, which one is correct, that no injury is noticed on the person in page number 29 of the accused, heard the accused / learned advocate for the accused. And we have gone through the record, Lordship. In the record, my lord, it is written, it is Wakalatnama filed on 13 October 2020. I have flag mark also. And my lord, I found a inspection memo. It is in the inspection memo, it is written that information was sent to the family member through the WT message. It is written in the inspection memo, my lord. So that means on that day, my lord, there was no communication. They have not communicated to the family member of the accused person under section 58. CRPC. So, my lord, that is one of the ground in this case, my lord. So earlier occasion, it was not, I think, placed properly. That is why, lordship. And then this Okalatnama and all this were not before your lordship with the record. Because to my, so far my knowledge goes, my lord, that was collected with the earlier LCR. Means earlier lordship rejected, and we made a request before this honorable court to call for that record. There, all the records are there. Only one witness examine after that. That is what that witness lordship called for, and the other records called for from
Till
the
now, how many
earlier.
witnesses?
Still 5. No witnesses examined, my lord. Earlier occasion also.
Listed witness?
My lord?
Listed witnesses?
Listed in 22. 22. And my lord, one more submission we have not brought earlier into occasions, my lord. This case was after such a charge was framed, then yes, I have annexed the charge head, lordship, at page number at page number 72. My lord,
6 8 was there, na?
yes, 6
6 8.
Yes. Sorry, no, my lord, 12 1 2024 at page number 72.
Yes, 72.
Yes. Here, my lord.
Charles was of 6 8. Charles
Yes,
was of
yes, yes.
with
6
6
8. 6 8. 6 8. Lordship, but lordship, see, you kindly see this. It was framed under section 392, and then lordship 396, 302, and 25, 18, and 34, and 27 plus 34. My lord, my first submission is that, lordship, in this case, 4 persons before the court. And as per section 392, 5 persons are required to frame a charge under section 392. Uh, 392 is for punishment for robbery. So, my lord, here robbery is defined when 5 or more persons conjointly commit, where 5 or more persons conjointly commit or attempt to commit a robbery, or where the whole number of persons conjointly committing or attempting to commit a robbery and persons present and aiding such commissions or attempt amount to 5 or more. Every person so committing, attempting, or aiding is said to commit dacoity. And then 391 is the definition regarding dacoity. 392 is punishment for robbery. Who commits robbery shall punished with rigorous imprisonment for a term which may extend to 10 years. Then here robbery is also defined at 390. 2 parts are there. Then 396, dacoity with murder. If any one of 5 or more person, in Buddha cases 5 person or more than that. Here charge frame for 4 persons, and against me there is no evidence at all. 22 numbers of witnesses examined by the investigating officer. They were interrogated. Here no allegation made by these 22 numbers of persons that I was involved in as per section 392 and 396, my lord. And also, lordship, no allegation that I have committed a murder under section 302. So only 120B and regarding 25 1A and 25 1A and 27 also is also not attracted to this accused person because there is no witness they have collected against me that I have used the weapon and I have provided that weapon. The person Zitumoni Burman who had provided the weapon, he got bail from this honorable court. So, my lord, and the most interesting thing is in this case is that, my lord, that weapon they could not recover because it was with, as per the statement of the this Shuzal Ali, as per 164 statement of Shuzal Ali, this weapon was one Bhupen Bora who has absconded in this case, lordship. It is mentioned in the charge sheet also. So, my lord, only allegation that they have collected, only allegation that as per charge sheet, lordship, they have collected CDR and the statement of the accused that this person, it is mentioned in the page number 58 of the charge sheet, lordship, of my petition, that they have collected confessional statement of one Sujal Ali, who is one of the accused in this case, and to our information, my lord, he expired in the jail hazard, lordship, recently, within 15 or 20 days back. So, my lord, this person has made a statement under 164 during custody and CCTV footage. And CDR collected all the other accused person, not from my, not my CDR was collected, my lord. It is nowhere reflected that my CDR, along with the charge sheet, they have placed, the investigating officer has placed. That is not there, my lord. So, here, if lordship, if there is no chance at all to convict me, lordship, I'm inside the jail for about almost 3 years, almost 2 years, 10 months, 23 days, and my lord, no witnesses they are bringing, my lord, till today. This last year, lordship, no witnesses examined at all, my lord. Whatever examined, that are all in the year 2024. Pass number two. Pass number two. In the year 2025, no witnesses examined at all, my lord. So, my lord, I'm local person, my lord, and the mandatory section also not compliant. I'm local person, my lord. So, my lord, any stringent, because my mother is a bedridden woman, my lord, and at any stage she may die, lordship. I'm the only son, my lord. That is why my humble prayer, lordship. Any stringent, because the person who got bail, he is also appearing before the court. One person expired, and one person will be inside. So, my lord, I'll cooperate with the investigating agency as well as with, I'll appear as and when fixed by the court, lords, in each and every day. My lord, any stringent condition may be provided. What counter?
First of all, lordship, regarding the grounds taken of section under section 50 and 50A, lordship, that no, the section 50 notice has not been served upon him, or section 50A notice has not been served upon him. Lordship, that has been, lordship, already on earlier occasion, lordship had decided, lordship, in page 88, lordship may kindly come. That has already been decided. So, lordship, again that issue, lordship may not appreciate, lordship. Page 88. Page 88, last paragraph, lordship, paragraph 20. Lordship, got it? That para 20, lordship, coming to the compliance of section 50/50A CRPC, it is rightly submitted by the learned additional public prosecutor that the present accused petitioner was produced only on the strength of the production warrant, and from the record it reveals that there are substantial compliance of section 50 CRPC wherein the case was heard, and in absence of his engaged counsel, one legal aid counsel was also appointed on his behalf to defend the case before sending the accused person to the police remand as well as judicial remand. More so from the other order passed by the learned court below, it is also that part also regarding. It is also revealed that after being satisfied the grounds of the reasons of arrest, the learned trial court below has allowed the prayer for police remand as well as judicial
remand, and the accused was also heard through the legal aid council before passing any order, and thus it cannot be said that he was not aware about the grounds of arrest, and also it cannot be held that there was default in compliance of section 58. So also when there is a warrant, it is the warrant itself is sufficient. We have already got it in several orders and judgments of Apex Court in Kasireti and other. Lordship is well aware about the if request, I can submit that judgment also. So Lordship, regarding section 50A, that I have not found that notice, Lordship, because all the notices are not here, Lordship. Even section 50 notice I also not found, because as it is scan copy and some documents may be left out. But Lordship, even though it is not for the timing, even though it is not furnished, then also Lordship, it is not a mandate of Article 22(1). Section 50 is the article mandate of Article 22(1) that has to be strictly complied with. Has to be there must be strict compliance. Even one more thing, Lordship, that he was arrested prior to the Pankaj Bansal case. 3/10/2023. That was the judgment passed in case of Pankaj Bansal, and from that onwards, Lordship, that written ground of arrest has to be furnished. That has come. So he was arrested as he was arrested prior to that. So also section 50 notice is not required, and that submission is also not required because he was arrested on the basis of the warrant. And section 58 also, that is also that is not a mandate of Article 21. That is a procedure laid in our CRPC. And in the case of Darshan Lordship, that is well established Lordship in Darshan, state of Karnataka versus Sri Darshan. That para 21.7 also it has been written. Observe that Lordship, there may be some procedural defect or procedural lapses, but for that he is not entitled for seeking bail. And apart from this, section 50 and 52, that framing of charges, that ground has been taken. Framing of charges, Lordship, if any section has been charge has been framed by violating some any provisions or that is not a ground for seeking bail. Yes, they can come for that purpose for seeking criminal petition by criminal petition in other way. But no, in the bail petition, only because of that section should not be incorporated. That cannot be a ground for seeking bail, Lordship. And thereafter, Lordship, that person who is that since long time it is not proceeded, because Lordship, already case is proceeding, and sometimes some witnesses come and sometimes some witnesses not come. Since 2024, it was charge was framed, and thereafter 5 witnesses examined. And Lordship will find in the case of Karnataka versus state of Karnataka versus Sri Darshan. In that case, Lordship will find that Lordship para 20.2.3 and 20.4. Some Lordship, that Lordship long incarceration, long list of witnesses, that may not be a ground of seeking bail when there is a when there is heinous offenses involved. And apart from that, Lordship, what the process is going on today in this court, if all the aspect has to be decided is to be decided in this court, then it will be mini trial. And in that case, Lordship, Sri Darshan has already stated, Lordship, that there should not be any mini trial. What is the how many witnesses examined, who has stated, who has left out, who died, who will prove the case, that will be a matter of trial. And High Court will not initiate a mini trial for allowing, for deciding any bail application. Only the issue is to be looked into, that also whether his involvement is there, whether we see after getting the bail, he may jump over the bail. That part has to be looked into. And I have flag-marked the some portion of the CD part, Lordship will may look into. That he is a heavy-shaded offender. Not only this case, Lordship. After that, Lordship, prior to that also, Lordship will find the one of the co-accused statement, Lordship, that main accused, Shah Alam, that I have taken mark. He is all along with him. They are the groups. They have formed a group of 5 peoples, and they are not only 1, 2, 3, 4. They have committed so many this type of Dakati incidents. And after this one also, Lordship, they have went for another. After this, no.
বেলেগ one.
এইটো নহয়, এইটো পুলিচ ৱাৰেণ্টত পালে আপোনাৰ তেনেহ'লে এতিয়া বেলেগ কেইটাত সোমাইছিল ন, সেইটো কথা কৈ আছো তেতিয়া মানে after this incident they have again committed one crime, that is also bank robbery case.
Which?
So Lordship, apart from the one by one they are engaging in any cases, Lordship. So Lordship, he is an habituated offender, and Lordship, if bail is allowed, bail is granted, there is every possibility of jumping over the bail. He will abscond, Lordship. He will not come back, Lordship. And at this stage, Lordship, so that Lordship, when there is a heinous offenses involved, when one person is died, Lordship, I think, Lordship, there will not be any more of heinous offense when person is killed in a roadside, Lordship, in open place, Lordship, by shooting gun, Lordship. So Lordship, that person may not be allowed to go on bail, Lordship. So Lordship, that much is my submission.
My lord, in this case, my learned PP has stated that last paragraph of the earlier order, Lordship, he has read out that here it is mentioned that more so, page number 88, more so from the order passed by the learned court below, it also reveals that after being satisfied the grounds and reasons of arrest, the learned trial court below has allowed the prayer for police remand as well as judicial remand, and the accused also heard through his legal aid counsel before passing any order, and thus it cannot be said that he has not aware about the grounds of arrest, and also it cannot be held that there was default in compliance of section 50 and 50A. My lord, I have gone through the record, and flag mark also, this yellow color flag mark is there, my lord. There was no counsel, my lord, at all, because I have on last occasion learned PP was not there, some other person was there. So my lord, on that occasion we made a submission before this honorable court that earlier record is there. That record may kindly peruse, my lord. That was our submission, my lord, on our part. So my lord, in that record may not be all these things. That is why on last occasion I made special request before this honorable court to call for all the lordship also permitted that. So my lord, that is why Okalatnama and all the things, even Hazira also, it is there on behalf of this accused person and other accused person, my lord. So my lord, as per the record, I have found that section 50 I do not find in the record, and right now section 50A is not mandatory, as my learned press has stated that 50 and 50, I need not to read again and again, because lordship many a times has gone on lordship passed the order first on this matter, my lord, on last year. So my lord, obligation of a person 50A making arrest to inform about the arrest to a nominated person. As per section 50, every police officer or other person making any arrest under this code shall forthwith give the information regarding such arrest and place where the arrest person is being held to any of his friends, relatives, or such other persons as may be disclosed or nominated by the arrested person for the purpose of giving such information. So my lord, it is shall forthwith, it is mentioned specifically, but they let them establish that or place before this honorable court, though earlier it was mentioned, but my lord, we have not gone through all the record, entire records, my lord. This time all the records called for, so it is before your lordship. So lordship, in their inspection memo, arrest memo, it is written that WT message sent to the family member, and order sheet of the learned CGM courts, both the courts specifically mentioned that there was no counsel in that case and this case also. In both the cases, same day he was arrested, he has expressed his view that I am not in a position to engage the counsel. So After that, legal aid counsel was provided, not on that day, for next day. That was asked to the court master to inform, or the officers to inform the legal aid counsel. That is specifically mentioned in 16 to the 2023 order, 16 to 2023 orders of the CGM Kamrup Amingaon. So, my lord, later on, the IO made a prayer. On that day, he placed before, produced before this learned CGM, my lord. How it is possible, lordship, to engage if he cannot engage a counsel on that day? Same day he produced in Guwahati. So, is it possible for the on the part of the accused to engage Guwahati itself, the a counsel on that day? It is reflected in the order sheet, my lord. And 50 those here mentioned, but no document at all. Let them test, lordship. We are not in hurry. At least a right order should be passed, lordship, in favor, because a person not in the jail for about 1 or 2 months, he is inside the jail for about 3 months, 3 years. So that is. Let me finish.
After killing one person,
it will be they have to produce establish their case, lordship. Let them establish. So many cases we saw that on the merit they reject after the trial court acquitted, my lord. Then how they can say that this person committed the offense, my lord? Well, lordship is experienced to that regard. After rejection of lordship also acquitted so many person after trial, lordship. Let me finish first. I did not disturb. So, my lord, regarding this issue, framing of charge, 392, 396, and lordship 25A, 1A, and 27, my lord. We have not challenged the charge because he is not in a position to file several petitions, my lord. He is very poor person. So, my lord, here charge is wrongly framed. Means 5 persons required to frame a charge under section 392. I am not on that. Whether charge is wrong or right, I am not on that. I need to show before this honorable court. That is why I mentioned these things, my lord. My contention is that whether under this section the person can they establish their case beyond reasonable doubt against me. Because of that reason, I am behind the bar. So, my lord, under this section, if the prosecution cannot establish the case after framing of this charge, then my detention in the judicial custody is futile, my lord. After 5, 6, or 8 years or 10 years, if I release, my lord, then who will get back these years? That is my contention, not on that section wrongly framed or rightly framed. That is not there. I know the law, my lord. If any charge is wrongly framed, that should be challenged. But he is not in a position to challenge these things, lord. Time and again, he filed the petition. We are doing these cases on his request only, my lord. So it is the thing that, and 164 statement recorded of the co-accused. My lord, 164, if co-accused recorded 164 statement, my lord, and alleged any involvement of any person, my lord, in that case, lordship, in that case, lordship, there are some principle to establish that 164 or extrajudicial confessions, my lord. My lord, without that, lordship, this is a case of circumstantial evidence, my lord. Whether this, though it is not a mini trial, even that, lordship, because 2-3 times already lordship rejected this bail petition, my lord. So, my lord, need not to say more and more. But, my lord, even though lordship, it's a circumstantial evidence, if they establish any authentic evidence against me, then I'll be inside. How many days they will take to conclude the trial? I'll be inside, my lord. Let them show that this evidence is against me and I shoot the person. And I had the meeting. I was in a conspiracy, except the one person statement and he is not right now in, he is expired, my lord, already.
Okay.
One more thing, Lordship, regarding that section 50 notice is again reiterated. So, Lordship, regarding section 50 notice, Lordship may kindly go to the language, Lordship. When a person is arrested without a warrant, first line, I think that is the first line. So, Lordship, section 50 is not applicable to the person who is being arrested on the basis of a warrant, Lordship. That is not applicable at all, Lordship. And if there, when there is a in the arrest memo, they have it is written, Lordship, that WT message was sent to the relatives. So, Lordship, when person is arrested here on the basis of a warrant, Lordship, so Lordship, on the same day it cannot be served. Go and that police will not go here for 2 days, Lordship. Bazali, Dispur police has arrested him, so Dispur police will not go to furnish that copy. So, Lordship, it has to be sent through WT message, Lordship. So that is complied with, Lordship. Even though it is not complied, then also my submission was that also it is not it is a procedural lapses, but it is a complied with because the WT message was sent to the relative that is written in the arrest memo, Lordship. So, Lordship, when section 50 is not applicable, section 50 is not applicable in the cases where there is a warrant of arrest, Lordship.
No. My lord.
Even, Lordship, will find, Lordship, that there are so many judgments, Lordship. In all the judgments, Lordship, all whatever the Bianco and all has come, Lordship. In all these judgments, Lordship, they are police has arrested those persons. There were nowhere person arrested on the basis of warrant of arrest. That is why in the case of Kasi Reddy, Lordship, it is in para 36, Lordship. Lordship is aware about, Lordship, that in para 36, Lordship, it is specifically mentioned, Lordship, when person is arrested on the strength of a warrant, that it is that it itself is sufficient to comply the sections 50, Lordship. So, Lordship, section 50 and 50A, this much I have submitted, Lordship, because all from since last 1 year, Lordship is repeatedly we all are repeatedly arguing on the same issue, Lordship. And regarding, Lordship, that, Lordship, in some cases, Lordship, even though in the case of, Lordship, I will submit one judgment, Lordship, that is NCP versus Kasif, wherein the Lordship, it is established that, Lordship, even though there are some lapses, in then also they are not entitled for bail. Here in this case, also section 52A of NDPS case, that was not complied with.
NDPS is other, their provisions are some other, Lordship. That stringent act that is referred to.
Even though, Lordship, there is special act, stringent act, even though, Lordship, even though, Lordship,
judgment, Lordship, in division bench, Lordship, we argued on that line.
Honorable Apex Court has stated, Lordship, that, Lordship, even though there are some provisions are not fulfilled, then also, Lordship, they are not entitled for bail. So, Lordship, what remains, Lordship?
My lord, see in this page number 28, my page number 28, he filed investigating officer filed an application before the CGM Kamrup Metro on 11/2/2023, and he placed this production warrant before the CGM Amingaon on 16/2023. He got 11, 12, 13, 14, 15, 16, 6 days. In the meantime, he did not inform the family member, my lord.
No, Lordship. After arresting the person, he will be informed.
No.
Why he will be informed? Because
No,
after arresting, why he was making such kind of submissions, Lordship?
No, my lord, why he is exciting, I don't know, my lord.
No submission has any value, Lordship. Because, Lordship, when person
my
is
lord,
not arrested, Lordship,
this is the
why
judicial
police
order,
will
my
go?
lord. This is judicial order, my lord.
If-
Can you
if-
see? If his officer is doing wrong, then
No,
his
officer is not doing wrong.
It was his duty to inform the family member to come to the court. I will inform.
After arresting the person, Lordship, if suppose, Lordship, if we have got the permission from the CGM court, but, Lordship, during that time, anything may happen.
If he
He
is
may
out-
get away from the
this
jail.
is not
Then
the way,
how
my lord.
will you inform him, Lordship? How
No,
will you inform the
this is
police?
not the way, my
No,
lord,
Lordship.
to make a submission.
Because
My
you are
lord,
interpreting my submissions,
my lord,
You are
kindly
interpreting my submission.
see the judicial orders, my lord. Kindly see the judicial orders. 16/2, on that day also nothing was there in that case. And he has stated in so many cases, if he is involved, his antecedents is not good. My lord, see, if a person arrest in one Blockati case, then this is the work of the police officer in state that you inform this name to everyone and arrest in all the cases and show the shown arrested in all the cases. Whether he is involved or not, that is the thing, my lord. After so many years, it will establish that this person is not involved. Court will accuse the person. This is the matter, my lord. See the kindly page number 27. It is the judicial order of the court. On that day also no counsel was there. There is
You have made this. I have noted down.
my lord, that is
No, I have noted down your submission that on that day also counsel was not.
yes.
In 16.2 itself,
Um,
it was
That-
produced.
Even and that is not actually also that is not required at all also because also when that section 50 notice is not required on that day LAC is appointed, he may not come on the same day, he may come subsequent days, lordship, on the subsequent dates, lordship. So lordship, this is not a provision, there is no anywhere provision that lordship that on that day the engaged advocate must appear before him before the court to defend him, lordship. There is no anywhere any law is there, lordship.
She was there. Nobody.
Maybe lordship.
No, nobody was.
LADC
That is
was
the law, my
appointed.
lord.
LADC
The my-
was
that is the
appointed.
law. That is the law. LADC was there by the court. Why they didn't
Where it
call for the?
I have not found anywhere.
No. Why the court did not call for the LADC advocate, my lord? So, my lord, on that day, that means no was there with him. That means no counsel was engaged. No family member was informed in that case also. So he was not informed his rights, my lord. This is the mandatory section, my lord.
If I may, my lord, an IA had been filed for impleachment of the district commissioner, Sri Bhumi, in this matter as the respondent number 11. My lord, this application was filed in reference to an order dated 21/11/2025, wherein it was determined that the
2111.
yes, my lord, paragraph number 3, my lord, and the last.
It is according to the last court's order.
So you have filed your IA.
We have filed the IA.
My lord, it may be allowed, my lord, because I had prayed for that. I am appealing for the state of Assam. I have prayed for the implementation.
Yes, perhaps. Administrator
G Imtiaz.
G. Iqbal.
G Imtiaz.
G. Imtiaz. Administrator G. Imtiaz, the responsibility. And petition.
C.K. Bhattacharya,
Visit Bhattacharya.
government advocate.
Government.
Appealing for the respondent
For the
7, 8, and the implemented party.
people and 7 and 8. Otherwise, you are appealing for 7 and 8.
Yes, and for the implemented party. Also.
Now you are appealing.
I am for the respondent number 1, 5, 9 and 10. Private.
You are Mr.
S. Islam.
S. System appealing for the respondent number 1 to 5, then
9 and 10.
9 and 10. And A. Bhattacharya, the respondent number 6, just revenue. And cost. This is an application for implement of the district commissioner, Sri Bhumi, as the respondent number 11. The above referred in the CRP IO number 40 of 25 under order 110 to CPC. It is submitted by Mr. Imtiaz that in pursuant to order passed at his court in CRP IO 240 dated 21/11. The presentation 25 bring for improvement of the this deputy commission as a party that the Senate Council set within punishing the amended cost title of a CRPI also with implementing the respondent, implementing the Deputy Commissioner, the respondent, party respondent. With the above observation, the present instance. ইফালে লিখক ইয়াৰ পিছতো লিখক আৰ্জেণ্ট in view of order passed in IA Civil 3855 of 2025. The Deputy Commissioner Sri Bhumi is hereby implemented as a respondent, party respondent number 11. After filing of the necessary amendment, after filing the corrected public amended post act of the petition, the petitioner will also take necessary steps in issuing summons. So you are going to appear, na?
No, my lord, summons will not be required. I am appearing. So
Yes,
that
I
is
see.
settled.
However,
And only a copy may be served, my lord,
however,
on the next day.
submitted
It
by-
can be done in court also.
However, it is submitted by Mr. Bhattacharya and committed that he is going to appear for the newly implemented respondent number. The copy of formal, in that case, no formal notice may be required.
And my lord, one more thing, to avoid delay,
However, the copy may be served. Let them file first.
yes,
case
my lord, to
amendment.
avoid delay, my lord, there will be, the instructions has already come. Actually, that is why I have prayed for the implement. Actually, though they were not a party, the instructions has come from the DC himself. And so our stand, my lord, just to shorten the case, my lord, after they file, that day, then when it comes up next, it may be disposed of, and my lord can record one line, our instruction. So that may solve the problem in the next day. So our stand is just that
On
the
the basis
parties.
of those instructions, are you going to file any written?
No,
form
that is
or
verbal.
further
My lord, that is all. That the parties. It is true that we know that the parties that were in possession of the land, they will have to be paid immediately. That is the fact. Irrespective of fact, who is the owner. But here, what has happened? They have not. They will have to show before us that the parties that were in possession, because the case is going on, no, we're in legal possession. That is what the problem. That is why we have, and it is a fact that we have withheld the compensation. So
once you withheld the competition on the other way, you are saying that they are in position. So take the stand properly
Yeah.
for the government side.
Yeah.
We have to be a government, you are appearing.
Yeah.
So
No,
don't
that
take the
actually
stand
we have
here and
already
there. Take
said
the
in
stand,
the
proper stand
lower
as
court.
per the government, because there the other respondents are also there. State revenue department is also there. So take a stand very properly. You have received your instructions from the department concerned.
Yeah.
You have already received. So you may make submission on the next date of listing. Let them amend the petition, and then only it will become up.
Yes.
If I may, my lord, our only stance is that we were a third party to the suit. Now, my lord, the order was passed without our presence, and my lord, it is beyond the.
Third party to the suit means you were.
We were not
there
a
in
party to suit. No, my
No,
lord.
you were
No,
not.
my lord. In fact, my lord, this land was not a
But have you
schedule.
filed any petition there to implement
Yes.
you as a party there? No.
Yes, my lord. We had filed an application that was rejected. That
Impede
order we have
to
challenged.
impede
my
you as a party.
Yes,
Yes,
that
ma'am.
is why I am
Because
saying.
your rights are there.
Yes, yes, my lord. If I may, my lord, that land was not a a part of the suit, my lord, which was filed. They have challenged a Swaran Lipi, my lord, settlement deed, wherein they have said it was mentioned. We are saying it was not. Now, my lord, we are only challenging this order on the ground that, as per the right to fair compensation and transparency in land acquisition, there is a section
So
63.
compensation now, who received the compensation?
My lord, we have not received.
You have
We
not.
were in
Withheld,
possession. It is withheld. My lord,
It has withheld.
Yes. By court's order, my.
yes, my
That is the order that is under challenge.
Yes, my lord, my only prayer is that, my lord, a short date may be fixed immediately after
You want a
vacation.
fixed date here?
Yes, my lord.
Okay.
The Royal Court, the case of the
Yes,
Royal
yes,
Court
yes,
has
yes.
been pending, my lord, after 5-2, your lordship. And a settlement discussion has been going on also. So this matter may be fixed on after 5 years.
Now, my
If-
lord, we are not a
Mr.
party to the suit, my lord.
February.
Islam. Mr. Islam, Mr. Islam, the non-conflict respond further submitted that there's a talk of settlement is going between the parties, and the Internet Trial Court video had fixed your date on 5 to 25, and according to submitted that matter may be fixed. after 5/2/2025 as detailed.
If I may, my lord,
Date may be
here,
fixed, man.
here, my lord, there's an issue, my lord. We are not a party to suit. My lord, any settlement that may be done would be between the plaintiffs and the defendants. We are a third party, my lord, and we are suffering because we have not received the acquisition amount, and the land has been taken from us. Hence, my lord, I pray for a shorter date.
That is the one issue.
Yes, ma'am.
That's right. Take up the Nili. Oh, you want to fix it earlier to
Yes, my
prior
lord. Yes, my lord. Immediately after vacation, if possible.
22nd of January.
Yes, ma'am. Deeply obliged.
Let us see. You can place your yes.
We have already filed.
And they will also have to show their legal possession, man, before the acquisition.
My lord,
It is important.
actually, the land was taken from us by the government, my lord. So, to that aspect, I guess, my lord, it is established. And the acquisition amount was supposed to be deposed to us, my lord. We had received the notice, which is a part of this IA, my lord.
Oh, that is
Yes,
the part of the I.
Yes, my lord.
Well, we'll see on the next date, man.
Yes, yes.
28.
Deeply obliged.
Lordship, you may kindly take up IS Civil 4152 of 2025. We have filed this application for withdrawal of 50% of the deposited amount deposited by the insurance company. I am for the claimant.
Okay. Do you have any issue?
Lordship, I have no objection subject to an indemnity bond, your Lordship, since we are denying liability in this case.
Otherwise, you are a respondent there.
Yes.
Applicant, respondent. And also part MSP return it. Also, the appearing for the respondent of the appellate MSC source. This is an application for withdrawal of 50% of the awarded amount. That is 1,89,131, which has already been deposited by the appellant, ICICI Lombard General Insurance Company Limited, in pursuant to order dated 9/6/2025, that is court, in ICB number 1844 of 2025, arising out MSC appeal number 248. It is submitted by Mr. Pallathekki that they are the claimant petition and is in need of withdrawal of the 50% deposited awarded 50% of the 50% deposited awarded 50% of the deposited award, which is lying before the registry. That is, as what there is no submitted that the money may be withdrawn subject to furnishing of the indemnity. Next part, the submission made by the petitioner is hereby allowed to withdraw the deposited amount, which is the registry, with a subject to furnishing the indemnity bond. And in the meantime, the registry is also hereby directed to disburse the amount after due and proper verification. Oh, where is the MSC appeal? Is there? What is the?
In the main appeal, there was the direction for taking steps upon the respondents, your Lordship. Accordingly, we have taken steps on respondent number
You are the respondent, claimant respondent number?
1.
You are?
1.
They are 1.
1.
1.
Respondent number 2 and 3 are the owner and the driver, your Lordship, and we have taken steps, your
You have
Lordship.
already taken steps?
Yes, we have taken steps.
Note 9. Okay.
Obliged.
29 minutes. IA 4200 of 25. Similar application for withdrawal of the amount deposited by the
Yes,
insurance.
Mr. Butler, do you have any?
No
objection. No objection. Similar. Okay. Amount which is 6,13,059. United India Insurance Company Limited, in pursuant to order dated 9/4/2024, That's why this ISC number 1101. Same order as it MSc appeal 154. Same. Okay, you were be at liberty to withdraw.
Fine.
Subject to punishing the Indian.
Obliged.
Main appeal, the service is completed.
Main appeal is not listed most probably today. You can pass the order. Heard Mr. K. Patil, learned counsel for the applicant. Also heard Mr. Secretary, learned counsel applicant. You are for the response number one.
One.
Yeah. Response number one. LCA receipt. LCA has already been received from office note. It 3/1/2026, it reveals their services completed on response number 2 and 3. However, no one is required. Let the matter be accordingly
For hearing.
listed for hearing or registry.
Obliged.
Lodge. I is only for
delay?
yes.
Delay was
Delay was of 176 days loss.
176 days. If insurance company is there,
No loss. The first time it is
no, yes, but it is appearing in the company name of the company.
ICICI Lombard. This is a
You're
private
going to
company.
appear ICICI Lombard. Okay, then we're issuing notice.
First time.
Heard Mr. J. Kali and counsel for the applicant. This is an application under section 5 of the limitation. Read with section 173 MPA for condoning the delay of 176 days in filing the appeal against the judgment and award dated 19/3/2025 passed by standard member MSCT Kamrup M in MC case number 2052 of the issued notice. The response to list 4 weeks will do. List.
But of like
Well, raising the issue of quantum.
in this case, no, basically, lordship, this I am the owner of the vehicle. So at the time of accident, lordship, what the person, two vehicles were involved, they have settled the case amicably, paying the expenses of medical treatment and all. Subsequently, they have filed this case lordship in MSc tribunal.
But what was the order of the
Tribunal has
You were
directed to pay and recover. Lordship.
pay and
Please, your Lordship. Lordship, IA, there are two IAs, Lordship, 3656 and 4097, Lordship. Lordship, 3656, IA number 3656 was filed praying for giving direction to the insurance company to deposit 50% of the awarded amount. In the meantime, they have deposited the amount. So this IA 3656 has become infructuous, Lordship. Subsequently, we filed another IA 4097 and praying for giving direction to the registry to release the amount that is deposited by the insurance company.
As regards withdrawal, your lordship, I have some objection, your lordship, so that your lordship, we may be given a week's time to file our objection, your lordship. Since the appeal is not on quantum, we have challenged the cause of accident.
No, I'm not pressing that IA, Lordship. 3656, they have already deposited. That was.
Deposited, but regarding withdrawal, we have objection.
I am not. I'm saying that I'm not pressing this IA. That was prior to giving direction to the insurance company to deposit that amount. That order is already there, Lordship. Or Lordship may kindly come to the order dated 2710.
No, I'm not on that. You are saying that 3656 has already become infrastructure that they have already deposited.
Yes.
Deposited it
Yes.
50%. Now
And-
another I is for withdrawal. Is it?
No, not withdrawal.
What is this?
For giving direction to the registry to release the amount that has been deposited. What objection?
We have objection because we are denying liability.
They are saying that
They have already deposited, otherwise they would have.
Regarding deposit, that is a statutory requirement. That, yes.
Statutory measure, it
The
was
time of admission, we have to deposit.
it was
this date,
a precondition most probably,
yes.
that's why they have deposited, but regarding the withdrawal, they have some issues. I mean, some objections.
At best, they can, I can furnish a indemnity bond and they can, registry may release the amount that is.
May be given for filing the affidavit. After that, your
Take some
lordship may
inspection
consider this
if it is-
petition.
Is a dead case or what?
The date case,
Date
but.
case.
Appeal memo has not been
It's
furnished to me.
Cause of accident, it was not due to motor accident, but due to falling from height. That is, we have challenged that point.
Trial
Lordship,
court
so
order,
regarding-
trial court award is already there, lordship. That is to which, that has to be put.
A week's time may be given to file the objection. After that, your lordship may consider this petition.
With regard to 3656, that may be
We can dispose.
not best lordship. Since they have already deposited them.
You're Mr. Chauhan or?
I am P.
Chauhan?
Mojumdar, lordship.
P. Mojumdar.
P. Mojumdar.
P. Mojumdar. Administrative Mojumdar, Learned Counsel for IS 3656. Bench. And also heard MSP Board. Learned Appellant. This application is filed, praying for a direction to the appellant. Topic Shriram General Insurance Company Limited to deposit 50% of the awarded amount in which was awarded in MSC case number 3/2017 by landed member MSC. But it is submitted to Mr. Mujumdar that they have already deposited the awarded amount, 50% of the awarded amount, and hence
18/11/2024. 18/11 as per my instruction.
11/2024, and hence
18/11/2025.
sorry 18/11/2025, and hence they are not going to press the in view of this the present IA. Now IA
4097.
4097
97.
4097 not here, but same so and so. This is an application praying for direction to the registry to release the deposited amount of rupees 6,11,350 by the appellant Public Insurance Company. In that context, MS Waterfall submitted that they need 4 weeks time to file their written objection, as they have written objection prior out, released a matter for 4 weeks, enabling the respondents Public Insurance Company to file the written objection. See,
Lordship, they have asked for a short accommodation. I think a week's time they have asked for.
1
week's time.
Yes.
A week's time.
It may be come immediately
After vacation.
Okay, okay. I had 4 weeks. Okay. Immediately after vacation.
Yes,
What,
your lordship.
here, you want any fixed date here or?
Lordship may fix that.
It will be definitely, it will come after last week of January.
Yes, Lordship.
Because after Bihu is already.
27, 28, 29.
Yes,
It is.
can be.
28.
Can be, okay.
28 January. Obliged.